muted. You will have an opportunity, of course, to ask questions throughout. So we've allowed everyone to have the opportunity to have a audio, but please keep that audio mute throughout the training so that we'll have a clean video. But just to let you know where you are, you're in the right place. This is Open Meetings Act training. My name is Niquelle Allen. I am the Director of Open Government and the Office of Open Government with the Board of Ethics and Government Accountability. I have at least two of my colleagues here that I see. I have Anthony Scarborough, who is our attorney advisor, and Chief Counsel Johnny Barton is also here with us. So today we'll be going over the basics of the Open Meetings Act. It's 10:02. I'm going to give a couple of more minutes and just go over some housekeeping matters in the beginning here. So this meeting is being recorded. We will provide a copy of the recording after the training is ended. And again, we'll ask everyone to please mute your line to make sure that you'll be able to hear me during the training. If you have a question, please unmute yourself and ask the question. It is permissible to interrupt me, or you may put your question in the chat. Attorney Scarborough or Chief Counsel Barton will be manning the chat and will either alert me to answer the question or they'll answer your question directly in the chat. So we're looking for a very fruitful training this morning. So we're going to be going over the basics. If you're a new board or commission member, this will give you a good overview. And if you are a seasoned member, this will give you a refresher and hopefully help you run your meetings a lot more efficiently and in accordance with the law. We do have another training this afternoon at 1 o'clock on parliamentary procedure with parliamentary procedure expert Susan Leahy. So if your schedule permits, we hope that you'll join us for that training as well. So the time is 10:03, so I'm going to go ahead and get started, and hopefully if there are others who will join, they won't miss too much. All right. So let's see if I can get this moving. Okay. So first about the Office of Open Government. So the Office of Open Government is an office within the Board of Ethics and Government Accountability. We enforce the Open Meetings Act and its regulations. Our staff is comprised of myself and director, Chief Counsel Johnny Barton, Cherie DeBerry, who is our attorney advisor. We have a trial attorney, Nicholas Weil, Anthony Scarborough, who's also an attorney advisor, Kimberly Brown, who is our paralegal specialist, and Kavan Bridges, who is our IT specialist. Our contact information, our telephone number generally is 202-481-3411, and our general mailbox is opengovoffice@dc.gov. Both are manned, so if you ever have a question, someone will get back to you with an answer. Okay, this is moving slow. Here we go. Now, the Office of Open Government's mission is to ensure that government operations at every level are transparent, open to the public, and promote civil engagement. The public has a right to observe government meetings and in some instances participate. The Open Meetings Act adds to government transparency and the public's education about government and education affairs through openness. So the idea is generally that when the public is educated, government democracy works better. So that's kind of the idea behind openness and government transparency. And also, since the government is making decisions, if the people know how those decisions are being made, are able to watch and observe, they're better educated, but then also things aren't happening behind closed doors. They're transparent, and the public knows how we as a government and we as educators are thinking and making decisions. So that gives us more credibility in how we operate. So the Open Meetings Act, which is found at DC Official Code Section 2-571 through 580, requires that any gathering of a quorum, which is key, of a public body where the members of that public body consider, conduct, or advise on public business, these things are key, offer the opportunity for the public to observe the meeting. The Open Meetings Act also requires that the public be given proper notice, and you're going to hear about that later, what that means, of that meeting, and they're afforded the opportunity to review recordings of public meetings upon request. Someone has I'm hearing something, so if you could please mute your line. So the Open Meetings Act is triggered anytime there's a gathering of a quorum of a public body. Now, these gatherings can include hearings, roundtables, regular, special, or emergency meetings. And the thing that they're doing again are considering, conducting, or advising on public business. And that's found in DC Official Code Section 2-574, Section 1. Now, public body does not include the courts, the mayor's cabinets, and advisory neighborhood commissions. So the applicability of open meetings. So as I just said, every regular, special, emergency, or called meeting of a public body that falls within that definition I just read must be open to the public. So a public body, which you'll learn in a few minutes, is defined in the Open Meetings Act, and this is a threshold matter. So that means that must be satisfied before the Open Meetings Act applies. So it only applies to public body meetings that meet that definition that was in the previous slide. So what is a public body? So a public body means any government council, including the Council of the District of Columbia, board, commission, or similar entity, including a board of directors of an instrumentality, a board of which supervises or controls an agency, the board of trustees of a public charter school, or an advisory body that takes official action by the vote of its members convened for such purpose. And that's in DC Official Code Section 2-574, subsection 3. So that's the first thing that the Office of Open Government looks at if anyone says, hey, there's an Open Meetings Act violation. The first thing we look at is the entity a public body? So those of you that are here, your entity should be a public body. Public charter school boards of trustees are a newer public body. So we're glad that you all are here learning the ins and outs of the Open Meetings Act. So we haven't had a lot of experience with public charter school boards of trustees meetings, but I will say so far so good. So again, the Open Meetings Act specifically includes these entities as public bodies. Government councils, the Council of the District of Columbia, that's probably the most well-known public body in DC. That's usually what people think about when they think about public meetings and public bodies. And I will say, if you'd like to see a good example of how a meeting is run, you may want to watch some of those council meetings. Boards are public bodies, commissions, board of directors. An example of that is the University of District of Columbia Board of Directors. Advisory boards that take official action through the vote of its members convene for such purpose. That's kind of a catch-all. And board of trustees for public charter schools. As we said, that's our newest addition. So exclusions are important because, again, the council passed this law, wanted to make it clear who was in and who was out. So a district agency or instrumentality other than the board which supervises or controls the agency or the board of directors of an instrumentality is not a public body. The District of Columbia Courts is not considered a public body. The mayor's cabinet is not considered a public body. The professional or administrative staff of public bodies, when they meet outside the presence of a quorum of those bodies, and advisory neighborhood commissions. So I'll just say a special note about ANCs, they have their own open meetings laws, and the Office of Open Government does not enforce those laws, but they have their own set that governs their meetings. So again, what is a meeting? So a meeting is defined as any gathering of a quorum of the members of the public body, including hearings, roundtables, whether formal or informal, regular, special, or emergency, as which at which the members consider, conduct, advise on public business, including gathering of information, taking testimony, discussing, deliberating, recommending, voting, regardless of whether held in person, by telephone, electronically, or other means of communication. So you see with this definition, the council meant to capture a wide range of gatherings um, that would be a meeting. So it doesn't have to look as formal as a council meeting. So it might be a smaller meeting, which a lot of you do, where you're around a conference table and you're, when we were in person and you were having discussions about budgets and other matters, which is public business. Normally now we are on Zoom or um, on another online platform, and we're having discussions, and those are meetings. That's usually what we see these days. So all meetings where there's a quorum are open to the public unless it falls within a closed session exemption. Now, quorum is key. We're going to be discussing quorum shortly. And so the exception to open meetings or closed sessions is something that has to be disclosed to the public. So you can't just close a meeting on a whim. It's something that you have to let folks know about in advance, and there's specific reasons for closure, which we will let you know of shortly. And also, unless established by enabling legislation, mayor's order, or regulations, we view a quorum as half of the members of the public body plus one. So if you get 10 members, a quorum is 6. So divided 5 plus one person is 6. So a minimum number of members of a public body must be present at its meeting to make the proceeding valid. That's a quorum. So always keep that in mind. So know what your quorum is. So whenever that quorum gathers and you are considering conducting and advising on public business, that means you're having a meeting. So what's not a meeting? A chance gathering, a social gathering where no business is discussed is not a meeting. So my colleague, Chief Counsel Barton, likes to bring up Costco, which is where a lot of us tend to gather these days, especially around the holidays. So it might be, you might see all your colleagues at Costco in line. So if you do see them in line, don't talk about any business because you might end up in a meeting. But if you're just there and you're talking about the weather or talking about the commanders and just anything general, that's not considered a meeting. A press conference is not a meeting. Email exchanges between you all, between members of the public body, that's also not a meeting. Subcommittee meetings are not considered a meeting subject to the Open Meetings Act. I'll put a caveat on that. If you have subcommittees, make sure it is not a quorum of the members present in that subcommittee. So, for example, in that public body of 10, subcommittees should be 5 members or less. So if there's 6 people there, that becomes a meeting that is subject to the Open Meetings Act. So what does it mean to have an open meeting? So here are the requirements. So according to the Act, an open meeting means the public is permitted to be physically present. So in our new world, virtual is physical. So in this case, if I was a public body of, I guess, 3, would be me, my colleague Johnny Barton, and Anthony Scarbo. Having the rest of you all physically present, you all are here with your virtual presence. So you all, the public, and you're here, so that qualifies. The news media is permitted to be physically present or virtually present, or the meeting is televised. Also, currently due to COVID-19, a meeting is open to the public if the public body has taken steps reasonably calculated to allow the public to view or hear the meeting while it's taking place, or if it's not technologically feasible, as soon thereafter as reasonably practical. So as I said at the outset, we're recording this meeting. So if something happens and For technical reasons, everyone gets kicked off the meeting. As long as the meeting is being recorded and I'm able to provide the recording after the meeting for everyone to view, it's not running afoul of the Open Meetings Act. So we're kind of in new territory here. And these are things that I don't have answers to today, but we're going to be figuring out in the near future kind of what does an open meeting look like in a virtual world. So I'll be looking to hear from all of you about your thoughts on this in the near future. Um, but today, this is what we have. So the public is able to be physically present. The news media is able to be physically present, or the meeting is televised. And right now, the public doesn't have the right to a real-time viewing. They just have a right to be able to view at some point. So that's where we are with an open meeting. And I hope that made sense. And if there are any questions, again, please put them in the chat or just unmute yourself and ask the question. So what are the exceptions to the open meeting? So I mentioned before that there are situations where you can meet in private and have a closed session of a public meeting. The board that I report to, which is the Board of Ethics and Government Accountability. We kind of do it the old school way. We call it executive sessions, but probably the proper way, the best way is called a closed session of an open meeting or a closed meeting. So on this slide, we have all the sections that are in section 2-57B, which I will read, that are categories of reasons for closing a meeting.
Next slide, please.
Was there a question? Okay. So the categories are court order or statute permits the closure. You're having contract negotiations, and that makes sense. And a lot of these are going to make sense to, why you would be able to discuss these things in private. Attorney-client privilege. And again, with attorney-client privilege, if you have someone there other than the parties, that breaks the privilege. Trade secrets. They're no longer secrets if they're public. Testing and grading examinations. That kind of goes without saying. Personnel matters. Evaluations by eligible charting authority. Trainings of public body staff. If you're discussing students' personally identifiable information. Collective bargaining negotiations, deliberations and adjudication actions by a public body exercising quasi-judicial function, public safety, disclosure of an honorary degree, scholarship, or prize, disciplinary matters, investigation of criminal or civil misconduct. So now we're going to move on to notice. I see a question, would potential fundraising fall under trade secrets? I would probably need to know a little more about what is involved. Let's see, talking about specific individuals who are interested in giving and how much they would want to give. I might have to contemplate contemplate that a little bit because trade secrets, the way that it is usually interpreted, does not contemplate that particular scenario. But that is interesting. And again, as public charter schools are new and have different issues, that raises different issues. As I'm thinking this through, then that might be something we need to talk about offline. I'm thinking that might fall into personally identifiable information. It may fall into, but that students. Paige, we probably need to talk offline about that specific instance. But I know that does apply to a lot of folks who are in this training. But that is a very good question. And I will actually kick that over to Chief Counsel Barton. Do you have any thoughts on that? Because I'm trying to think of it, because a lot of these exemptions also fall into into FOIA, which doesn't necessarily apply to public charter schools because you all aren't governmental. But that is a very good question, and I know there are a lot of those things that do come up kind of in nonprofit world that are not necessarily analogous to government. I see why you would want to keep that private for numerous reasons, so that is very personal. But so you see how my mind is working. So Paige, yes, I will talk to you offline, and thank you for sending me the email, and thank you for the question. So let's get into notice. So DC official code, and let me say this also, there are also some matters that might be more appropriate for a subcommittee. So that may be one of the matters that could be appropriate for a subcommittee. So donations, donors. So if you may have a donations subcommittee, and then who considers those types of matters, and then brings the full matter to the general body. So that's kind of how I'm thinking you could resolve that one way, but we'll talk more offline. All right, notice requirements. So DC Official Code Section 2-576 deals with notice. So before meeting in an open or closed session, a public body shall provide advance public notice regarding the meeting. Notice shall be provided when a meeting is scheduled or when a meeting is changed. So again, this is advance notice. So you think about, you want people to be able to come. So it's just like if you're having a party, you want to let people know in advance so they can show up on time and show up appropriately. So the Open Meetings Act gives you a specific time period for the meeting. In most instances, a public body must post notice as early as possible, but no less than 48 hours or 2 business days. So just kind of put that in your mind. 48 hours or 2 business days, whichever is greater before the meeting, is when you must provide notice. If you're responsible for that, you may just want to put it in your phone or put it in your calendar so that you know that this notice must be posted, and you can do it in advance of that, but that is the notice requirement. So where should the public be, where should the notice be posted? So in a pre-pandemic, we used to require physical posting. That's no longer required. Notice now must be posted on a public body's website or the district government's website, which is the central meeting calendar, which is our website, which is open-dc.gov. And if you would like to post on our website, we're happy to provide you assistance with doing that. Our IT specialist, Kavan Bridges, will assist you with doing that posting. And we'll give you credentials to do that. So I'm going to kind of extract notice for emergency meetings and special meetings. So a public body may find it necessary to call an emergency meeting to address an urgent matter. So in those cases, notice shall be provided at the same time the notice is provided to members. And the notice must be provided on the central meeting calendar or the public body's website at that time. So an emergency generally means the meeting is necessary to prevent harm to public safety, health, or welfare. So this is something real serious, is when you would call an emergency meeting. Now there are also special meetings. Special meetings is not an emergency meeting. A special meeting is called outside of the normal or regular meeting schedule. And those meetings must meet the 48-hour 2 business days notice requirement. So you can have meetings outside of your normal meeting schedule, but those still have to fall under the notice requirements. Now this can come up because some public bodies predate the Open Meetings Act and may have bylaws that say, we've had this come up recently, a public body where their bylaws said they can call an emergency meeting and that whenever. But their emergency meeting did not fall within the definition of the Open Meetings Act emergency meeting. So there was some confusion there. So always know that the Open Meetings Act comes first before your bylaws. So if your bylaws do not comport with the Open Meetings Act, you need to make sure that you amend those, because it could be something very simple with the language that just is not the same. So just make sure that you know that if you have something in your bylaws that's about an emergency meeting, that it needs to be an urgent matter that's necessary to prevent harm to public safety, health, welfare. So, for example, during COVID at the beginning, we had a lot of emergency meetings, and that goes without saying. So those sometimes could not be noticed because something urgent was happening. So those are the types of meetings that the council had in mind when they drafted this provision. But it's permissible to have a special meeting outside of the normal course of your meetings. But again, those have to be noticed just like at your regular meetings. And I see a question from Chloe. Why is notice of a closed session required? Um, Notice of a closed session is required because the public needs to know that you're not meeting behind closed doors, doing something secretive. Um, that's kind of the antithesis of open government. So yeah, the public just needs to know that hey, we are meeting. It's for these specific reasons and it's permitted. So that's why again it's for transparency. So an example is we're meeting to discuss a legal matter, and I'll get to it in a couple of slides, but there's a procedure. So you are having a open part of that meeting, and it's recorded, and it's done in this way, again for transparency and openness, to give the public confidence that everything you're doing is above board and transparent, and that's really again what I said in this kind of beginning. The spirit behind all this is to make sure that the way we are all operating is to give the public confidence that we are operating in a way um, that is ethical, that is open, and that we are not doing things that are kind of outside of um, the scope of what we should be doing as public officials, as members of boards and commissions, and that we are executing the offices that we hold in a way that upholds the public trust. That's kind of the general idea behind all of these laws, and why we execute them in this way. So going back to notice. So what should actually be in the meeting notice? So first, the date, time, and location of the meeting. So location now in the virtual world means link to the meeting that someone can access. So that information should be in the meeting notice. So what can I click on? What's the website? How do I get that access? A meeting agenda. So that's to let them know what's happening, what's going to be discussed. And going back to the previous question, if there's going to be a closed session, um, letting the public know that you are closing a portion of the meeting, including citations to the reason for closure. So if there's one of those, that list I read a few slides ago, which the reasons for closure are under section 2-575B, you're going to describe those matters, why you're closing and what you're going to be discussing in the closed session. And important to us, and your agenda, you need to let the public know, and this helps you too, that if they have a problem, they contact the Office of Open Government. So this statement should be at the end of your meeting agenda, which will be, you'll usually have a draft agenda in your meeting notice, but this meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. So this gives the public information that if there's a problem, they can contact my office, the Office of Open Government, and be provided with assistance. Meeting procedures. So DC Official Code Section 2-577 sets forth the procedures that you follow when executing your meeting under the Open Meetings Act. So meetings may be held electronically or in person, so long as the public has access to the meeting. A public body's meeting should be recorded. All votes during a public body meeting should be taken by roll call. And this is for electronic meetings in particular. Again, one of the issues that we are needing to be aware of in general is access. We have a lot of different folks in the District of Columbia who have different needs. There are folks who are visually and auditory impaired. So saying who's here, saying who's doing what, provides clarity so people know what's happened. So kind of a roll call vote accomplishes that. So that's an example of, Niquelle Allen votes aye. So someone who's reading a transcript is clear what my name is, what I voted. Those types of things are important, and we need to keep those in mind. Again, these are things kind of looking forward into the virtual world that we're in, and making sure that we're including everyone, that we have a clean record, that everyone knows what's happening, that if one of your faculties is not clear, that we make sure that once we have a record, that these things are taken into account. Now, as far as procedures, again, and I stress, we must have a quorum in order to conduct business. So the chairperson at the beginning of a meeting needs to conduct a roll call and establish a quorum is present in order to conduct business. So if we have any chair people who are present here, when the meeting starts, if you know with our theoretical public body of 10 that you need 6 members, you need to make sure you establish that there are 6 people present in that electronic meeting, so that you can start your meeting. So if there are not 6 people there, you're going to have to end the meeting, and you're not able to conduct business on that day. You'll have to reschedule or do something else. But a quorum is required to conduct business. And you need to kind of get that out of the way in the beginning. And this is something that we'll kind of be discussing in more detail this afternoon with Susan Leahy, kind of about those parliamentary procedure questions about how to do this. So I see a question: in meetings held virtually, could a quorum be established by seeing who's present on Zoom rather than doing a roll call? Again, we want to, when possible, establish that clear record. So again, it does seem like, yeah, well, I see the names, so why do I need to call them out? Again, it's doesn't take a lot of time, and the law requires it. And sometimes it is good to just say good morning to everybody, have everyone acknowledge their presence. It doesn't have to be formal. Could be fun, saying, "Hey, I'm here, I'm here, I'm here." Getting everyone engaged at the beginning of the meeting. But again, just think about it as establishing a clear record of the person's presence, getting their voice on the camera. There are a lot of different ways to do it. And again, not just thinking about yourselves as a public body, but also thinking about folks who are watching, people who might be on the phone. who can't necessarily see the screen on Zoom. That sometimes happens. We had a couple of people on the phone here. They may just be auditory and not visual. So just always keep in mind, we've kind of got a wide range of folks who might be listening or participating. So we need to make sure that we capture all of those people and give them an opportunity to participate. So when an emergency meeting is convened, the chairperson must open the meeting with a statement explaining the subject of the meeting and the nature of the emergency and how the public was provided notice. So this is key in the emergency meeting. So, for example, if it's let's say, let's just go back to the biggest emergency we've had, COVID-19. So let's say you're meeting because you need to close a school due to a COVID-19 outbreak. The chairman would say, we are meeting because there was a COVID-19 outbreak at X school. This is an emergency that we need to address. The public was provided notice of this meeting on our website, schoolx.edu. And that is the procedure for an emergency meeting and providing notice of that meeting. So that's required when you have an emergency. Let's see, I'm seeing another question in the chat. And you're welcome, Michelle. Okay. So the next topic I'm going to deal with is entering into closed session. So there is a procedure for entering into closed session. So all meetings are open in the beginning. And so before a meeting or a portion of a meeting can be closed, the public needs to be able to be present at first. So the public body shall meet in public session at which a majority of the member of the public bodies present need to vote in favor of closure. So the presiding officer, usually the chairperson, will make a statement providing the reason for closure, citing the citations from DC Official Code 2-575B and the subjects to be discussed. Like, for example, we are closing this meeting pursuant to DC Official Code Section 2-575B for attorney-client privilege to discuss a legal matter. Someone will make a motion, not the chair, to close the meeting. There will be a second and a vote, a roll call vote to enter into closed session. If there is a majority vote in favor of entering into closed session, the public body may enter into closed session. A copy of the roll call vote and the statement shall be provided in writing and made available to the public. Again, this is why we go through all these exercises to make sure that there's a clean record of what happened and why, because people may complain. So you want to make sure that you had all of these things in the record and done properly. So you know why you did it, everybody agreed to it, and this is what happened. A public body that meets in closed session shall not discuss or consider matters other than those listed under DC Official Code Section 2-575B and the ones that they voted on in the public session to meet on. So if you get in the closed session and you want to talk about something that's appropriate for the open session, you got to go back in the open session and talk about those things. So for example, if you get in there and you want to talk about, and you want, sorry, and you want to talk about something else that's appropriate for the open meeting, you need to go back in the open meeting and have that discussion. I saw something in the chat pop up. Let's see. Did I, hold on, I think I see a question. Okay. Thank you, Johnny. Johnny got the question. And if necessary, the chairperson should resume open session to report publicly any official action taken in closure and adjourn. So if there's something that you all voted on that the public needs to know about, you end your closed session, you go in public and adjourn, but you still can go and adjourn the public session and adjourn the full meeting. recordation of meetings. So DC Official Code Section 2-578 discusses recording your meetings. So meetings have to be recorded by electronic means. If electronic recording is not feasible, a public body may provide detailed meeting minutes. We're not finding nowadays that that's the case because we've got Zoom and WebEx, Facebook Live, all other types of recordings. So this is phones. There's so many ways to record a meeting now. So I want to say this is in the pre-COVID days, but we're all pretty adept at meeting recordings now. The electronic recordings or detailed meeting minutes must be preserved for a minimum of 5 years. So make sure that you have someone who is responsible for keeping that record. There are 4 different ways to record your public body meetings: audio recording, video recording, transcripts, and detailed meeting minutes. But the easiest way, of course, is what we're doing today, having a Zoom meeting or WebEx meeting, and just hitting record. Copies of records shall be made available for public inspection according to the following schedule, provided that a record or portion of record may be withheld under the standard of established for closed meetings pursuant to DC Official Code Section 575B. Hopefully this is on the next slide. Or I have it in my mind. Yes. Sorry about that. Publication schedule. All electronic files, meeting minutes, and transcripts must be maintained by the public body in accordance with the document retention schedule or the document retention schedule of the government agency or the school. If the government agency is not instructive, the public body shall rely on the Open Meetings Act. So that's 5 years. DC Official Code Section 578B1 states a copy of the meeting minutes shall be made available for public inspection as soon as practicable, but no later than 3 business days after the meeting, or in the case of a board of trustees for a public charter school, no later than 30 business days after the meeting. So public charter schools, you have 30 business days after the meeting. The majority of public bodies are unable to post meeting minutes within 3 business days required under the Open Meetings Act. So draft meeting minutes must be posted 3 business days upon the conclusion of the meeting, with a notation at the top of the document that full meeting minutes will be posted to the website on the next meeting date of the board or commission. Because usually you have to vote. I'm not usually, you have to vote to approve the minutes for the previous meeting at the next meeting. So that's why you post the draft meeting minutes. Under DC Official Code Section 2-578B2, a copy of the full record, including any recording or transcript, shall be made available for public inspection as soon as practicable, but no later than 7 business days after the meeting. So we're making this presentation available to you after, and there's also going to be a checklist that you'll see. So you'll have all of this information with all these times. So remember, just put it in your mind, 3 business days, 30 business days if you're a school, 7 business days. Open Meetings Act compliance. So we hope we never have to do this, but we do have the ability to take compliance actions. We like to have education and see you all in training. So that's our favorite thing to do. So we never want to do compliance, so we do have the ability to take compliance actions. So an agreed party, including anonymous parties, may complain to the Office of Open Government for relief if a meeting may have been conducted in violation of the Open Meetings Act. An Open Meetings Act complaint may address past meetings conducted by a public body. OMA complaints may be submitted in writing and can be done in person, first-class mail, email, and online. We may take enforcement action in DC Superior Court for injunctive relief for violations of the Open Meetings Act before or after the meeting takes place. The court may order a remedy that includes fines, additional form of notice, postponing a meeting, declaring an action void. We hope to never have to do this. but just know that there are penalties in cases where the Open Meetings Act is violated, and these are willful violations, which I know no one on this call would ever do. And we have not seen. We've only had one case that we've had to bring so far. So as I mentioned, and at the end of this training, you should be taken to this page. We have an Open Meetings Act checklist. So it's a user-friendly guide that you can just go through that will help you comply with the Open Meetings Act. We'll just take you step by step through what I've gone over today, and will help you to prepare for and conduct meetings. And that's it. Thank you so much for your attention today and for your questions. If there are any other questions, please unmute yourself or ask them in the chat. I think I see a couple of questions that Chief Counsel Barton answered already. And I don't see any others. So we have a little bit, got you out 10 minutes or so early. If there are no other questions, I guess we can adjourn. So thank you again for your time and attention. Again, we are the Office of Open Government. We are a small but mighty team of 7. We are here to assist you. We can attend your meetings and provide you assistance if you need us.
Will you provide this? Can you put a link to the checklist in the chat?
Yes. I will put that slide back up, and once you exit the WebEx meeting, it'll take you straight there. But here is the link at the bottom. We're also going to provide you with the with this slide deck, and I will email the checklist to you, or you can actually let me see if I can put it in the chat, or maybe let me see if this works. Well, there it is on the screen. So that's what it looks like. And let's see, can one of my folks, let's see if I can put it in the chat. Okay, so I just put it in the chat as well. So yeah, so that goes through everything we went through today. And again, if you ever have any questions, please reach out to us. We're happy to help. And again, we're happy to go to your meetings with you. If you need us to help you with scripts for your boards or commissions or your members, your chairs, we're happy to do that as well. So I don't see any other questions. So I will conclude the meeting. I think so. We got everything. Hearing no questions, I think I'm going to adjourn.
Hi, I just quickly, should we email you for the PowerPoint presentation, or will it be sent to all?
I'm going to send it to everyone, and it will be on our website. So I'm going to send a link to the website. But if
Perfect.
you would like if you want it right now,
Great,
just
thank you.
send me an email. So it's my first name dot my last name at dc.gov.
Thank you so much.
You're welcome. So I hope everyone enjoys the rest of your day. And again, thank you. If you have time, please join us this afternoon for our parliamentary procedure training. And we will see you then. So take care, everyone.